Part 2, legal approaches. In this section, we're going to approach the issue of fairness in AI, or fairness more generally, by talking about some legal approaches to fairness. So here we're going to talk about anti-discrimination legislation, and we're going to case study the EU, the UK, and the US examples. Then we're going to dig down a little bit, and we're going to talk about protected characteristics, because they form an important reference point for all of our discussions later on when discussing AI. The protected characteristics are very important. And then we're going to talk about substantive justice. So substantive justice is when you're making justice across groups, or by addressing certain historical events or systemic injustices, and so on and so forth. So let me begin by talking about the UK's Equality Act. So the UK Equality Act is a legislation that came in 2010, which discusses addressing inequality or discrimination based on protected characteristics that they define in terms of age, disability, gender, reassignment, marriage and civil partnership, race, religion or belief, sex and sexual orientation. This is really important because it's not traditionally questions about inequality or discrimination, especially in the 20th century, were very much centered on socioeconomic terms. So very much about class in traditional political philosophy. So I think this is a very significant shift in the way in which we think about equality very explicitly. I should say that in the legislation, it does talk about public sector provision to reduce socioeconomic disadvantages. And the way it does that is to say that when the government is hiring or when the government procures, should do so with socioeconomic inequality in mind. But when it actually goes down and names the characteristics or attributes which it considers to be of particular interest, it doesn't mention socioeconomic background, and I think that's very significant. Moreover, in the legislation, it talks about direct and indirect discrimination. And here we can start talking about proxy. So what is a proxy protected characteristic, let's say, or discrimination by a proxy? So here you could say that, look, let's say I'm discriminating according to region or according to a particular area. Now, if in that area there is a concentration of people from particular demographics, then even though I'm not discriminating directly against a protected characteristic, effectively via the proxy of a region or particular area, I am effectively discriminating against people on the basis of protected characteristics. So there we can talk about direct and indirect discrimination. That introduces a whole bunch of conceptual space and debate, which again comes when we discuss AI application. You can think about proxy variables in the context of AI. So in this legislation, it also talks about positive action measures. So this is a theme that's going to come up, and the language is different in different legislation, but we're referring very much to the same thing. We might think of this in terms of the positive discrimination discussion. So here is to think about actively addressing, let's say, historical injustice or groups that have been disenfranchised or discriminated against historically, that have led to particular kinds of inequality, and that it's lawful or appropriate, according to the UK Equalities Act, to take positive action measures. So that's going to come up later in our discussions, and it's a theme that emerges continuously. So let's talk about the EU legislation, and we're going to and notice that this is very much about the kind of legal traditions that these laws are derived in. But in this context, unlike the UK legislation, which just legislates an individual law, here the EU legislation on equality is rooted in their fundamental Charter for Rights. And there it talks about discrimination in Article 22, and it names sex, race, colour, ethnic or social origin, genetic features, language, religion or belief, political or any other opinion, membership of a national minority, property, birth, disability, age, or sexual orientation. I want to note, and probably we may discuss it a bit later, but note that there are there's lots and lots of overlap between the protected characteristics in the UK legislation. So, for example, gender is mentioned, race is mentioned, and so on. But there are some things which are different. For example, language wasn't mentioned. Genetic features. Genetic features can be interpreted in the British legislation, but you can see what I mean. So there's huge overlap, and there are some differences, but there's generally there's a lot of overlap in the effectively in the protected characteristics that are being identified. Notice also, like in the UK legislation, there was positive action measures. In the EU legislation, it talks about positive action directives. So here we're talking about what happens when you've got cases, let's say, of substantive injustice, or in the case I'm giving there of the European Central Court's 1995 ruling, which was to say if there was two different candidates that have the same effectively the same kind of CVs or backgrounds, could you decide based on the gender? And there they were saying, given that women have been historically discriminated against, the priority can be given to a woman, assuming all other things equal. So notice there is a difference in terms of where the legislation is rooted. So in the UK, it's another piece of legislation. In the EU, it's a fundamental question that goes back to kind of common law differences and European legal traditions. It has the same kind of mapping of protected characteristics, and it also importantly has all this kind of positive discrimination dimension at the bottom. So now let's look at the US legislation. So the US legislation, the Civil Rights Act of 63, 64, 68, and then there's these other legislations that come in after that amend and add to and so on and so forth, was a huge event. And notice that it's similar in this sense to the English or British UK legislation, which is not rooted in kind of first principles, but comes as a way to address inequalities. There's lots of statutes, and when you kind of distill it, you notice that the discrimination that's mentioned specifically is race, religious belief, national origin, and age, and so on, genetic information. Again, lots and lots of overlap with the EU legislation and the UK legislation, but it has other, let's say, idiosyncrasies. And one of these is, for example, veteran status. That doesn't occur in the UK or the EU legislation. I think that's very much to do with the kind of national culture. It's also important to think about the Civil Rights Act in the context of race relations in the United States and what it was addressing specifically. So we've got a similar mapping of protected characteristics and legislation. And finally, again, like the EU and like the UK, we have a kind of a provision, if you will, for positive discrimination. And here we're citing the executive order. This is the presidential order, where it talks about federal contractors using affirmative action to recruit qualified minorities, women, persons with disabilities, etc., as a way to address historical injustice or inequalities in society. So that's another form of positive discrimination. So we're starting to see a kind of pattern, if you will. We're starting to see a kind of similarity in all of the legislations, in the legislation that we've looked for. And here we've kind of mapped it out on the right. So all of these have the common theme of, say, gender or age and so on. And it's very much mapped. You have different kind of idiosyncrasies in different contexts, but most of it is overlapping with one another. And you notice that there is, in addition to these protected characteristics, there is a tension between the group justice and individual justice. So in some contexts, we're talking about, in the EU, when they talk about language and political opinion, that seems to me, or that screams to me, group. When we're talking about gender or disability, we're talking about individual. So this is really interesting to see this. We want to also talk about the fact that there is and I think a very fundamental approach to here, which is reasonable pluralism. So what do we mean by reasonable pluralism? So consider in all of these cases, an individual has, has to consider, in the UK context, 9 protected characteristics, and in different contexts, it needs to, the individual or whoever's making the fairness judgment needs to consider a whole host of protected characteristics, as we've shown here. One of the problems with that is that not all protected characteristics may be relevant in all circumstances. So there is increasing calls for what some people are talking about, interdimensionality or intersectionality, where you would consider, maybe gender and race and class at the same time, language and political orientation at the same time as disability and so on and so forth, and how these all interact with one another. But even in those calls, seldom, I don't think I've seen an example where every single protected characteristic is taken into consideration at the same time. And the reason I mention that in the context of reasonable pluralism is to say that, look, we're going to have different protected characteristics are going to come and be relevant at particular times, and those particular times will be relevant to the context. The context is highly important. So it's important for us to understand that in different contexts, different priorities are going to take place. So if you've got a context where overwhelmingly women have been discriminated against, then the protected characteristic of gender is more important. If you've got a context where disabilities, people having access to buildings and so on, then we might think that disability is more important. So our concept of fairness is very context dependent. We have to make decisions between these protected characteristics because often they sometimes come at the cost of one another, even when we're taking multiple protected characteristics together at the same time. Another issue here is we have problems of definitions. So notice there, gender reassignment, we're talking about sex, you're talking about belief, you're talking about age and so on and so forth, race. One of the paradoxes is that when you define in order to protect, then you necessarily exclude. So if I define particular groups, particular, let's say, belief systems as worthy of protection, but I don't define others, then I'm excluding. So we've got a problem of definition and inclusivity, and this is something which we're seeing more and more, people challenging definitions and challenging these notions and saying actually they need to be expanded or they shouldn't include this group or that group and so on and so forth. And that's very, very non-trivial, and that's something that is of major concern. And finally, we need to talk about how these concepts are rooted in particular contexts, and even though they're supposed to be inviolable, or we usually think of our fairness concepts as quite stable and universal, you can even see just from this, even though our, Europe, the UK and America are culturally very similar as compared to, let's say, ethical systems from different parts of the world, even here it's highly contentious. We've got lots and lots of difference of opinion on terms, on notions, and so on and so forth. So what are our big outcomes when we're discussing the fairness? One, we're relying on legal definitions and ethical definitions which are contentious. We need to make decisions between different concepts, which appeals to reasonable pluralism. It's impossible for us to comply to these in parallel. That's the point I was making about whether or not you're looking at 6 or 7 protected characteristics at the same time. It will be impossible to be compliant on all of them. We've got the tension between group and individual, and all of this is determined by context. So it's very, very messy and it's very, very complicated. So let me close this section by summary. Most of our fairness discussions that we're going to appeal to are appealing to concepts of anti-discrimination law or fairness equality legislation. We've discussed UK context, the Equality Act, in the EU, the Fundamental Charter of Rights, Article 21, and we've discussed in the US, the Civil Rights legislation. And in all of them, we're appealing to concepts of protected characteristics, which, as I've mentioned, are very contentious and at the same time, often very shared between the different legal systems. And we're talking about substantive justice. So substantive justice is to look at the context or the history of if particular groups have been excluded and not, and to make decisions accordingly.